Hello everybody. Today we are going to make discussion on a very significant concept called decree, order and judgment. Now the layman changes these three words interchangeably, but in law it is not so. There is a huge difference between these three terms, and in order to understand these three terms clearly, it's better to first be aware with the terminology used in these three definitions so as to understand it in a very clear manner as to what does it mean and what is the difference amongst these three definitions. So today we would be covering through aspects decree and order. Judgment, although I would be giving you an overview of the judgment as well, but the main focus and thrust would remain on these two terms, decree and order. See, since we are committed to give you clarity of all the concepts and the term which are bit complicated, this is our sincere endeavor to once again explain you the concept of civil procedure code or the civil code. Now we have recorded few lectures on CRPC on the different concept. I hope you must have liked it and you must have absorbed it fully. But here we have been starting up with the civil procedure code, or as you all know that the civil procedure code deals with the determination of the civil rights. It actually deals with the determination of the civil right by the court. Now we are living in a civilized society. We have certain civil rights and obligations. For example, we want that we should not be caused harm, hurt, and nobody should violate or infringe our civil right at any cost. Once these rights are infringed or violated, then we have a remedy under law. Now one of the fundamental principles of English law is ubi jus ibi remedium, meaning thereby that where there is a right, there is a remedy. Now civil courts have been meant to adjudicate upon these rights and give the verdict or the mandate in the favor of an aggrieved who is deserving one and who is able to establish his case on the merit. Now if I come to the definition of decree, which is a final outcome of a long drawn litigation in the civil code. Now first and foremost thing which you have to remember is that decree is always drawn in a suit. We do file applications, petitions in the court of law, but it is only in the suit decree is fine. The first and foremost difference from the order is that decree is always drawn in a suit. Now we explain. Decree means the formal expression of an adjudication. See, the question comes, if it is a formal expression of an adjudication, then there may be some informal expression also. Now what is that informal expression? Now if we see the definition of order under section 214, means the formal expression of any decision. See my dear friends, here you need to understand the formal expression of a decision and formal expression of an adjudication. One major difference. Now what does adjudication means? See, adjudication, the meaning of this word has not been defined, but if we say the plain dictionary meaning, it means a judicial process. Now it is only and only the courts are empowered to determine the civil rights of the parties who are subjected to private litigations and they are seeking some kind of relief. They come, they narrate their version to the court of law and they describe the facts and the cause of action. They describe the fact and cause of action by way of plaint. Now plaint we will be discussing in the next lecture, because again this is very important concept as to how the plaint is to be drafted, what are the procedure, mechanism and the precautions one has to take care of. For example, you would be narrating the facts and then you would be describing the cause of action. Then apart from it, the limitation, jurisdiction, the court fee, the subject matter and the relief claimed, all these things you will have to incorporate in the court of law so that court of law could adjudicate upon it by way of the power conferred upon the court by following the due process of law. Court has to see that procedure has actually been followed and no lapse has been made, and it is only within the conformity of law the subject matter before it has been decided. Now this is the primordial function of the court. Now see, adjudication is a judicial process. Suppose there are 10 members in a family. One is the elder being who's given due regard, respect and affection by the family, and he is being honored and his words are given due weightage in the family. Dispute arises between any two members of the family with regard to anything. May it be a financial issue or matrimonial or the contract, anything it could happen. Now they refer the matter to the senior most person. A senior most person issue a directive and sort of give them advice. Now, will this advice and the directive given by him have any persuasive value? If tomorrow they do not follow it, so what action could be taken against them? But in the court of law, it does not happen so. Once the directive is given, mandate is given, it is legally enforceable, and the party who does not, meet out his obligations or follow, he could be subjected to other, the penalty or the fine or the other penalties. So the question here is that adjudication is a judicial process. Okay. We see further. Adjudication which so far as regards the court expressing it. Now the word court. Adjudication only by the court. Court does not mean a room or a premises or a building. Court means which is being presided over by a person who has been empowered by law to decide and who has been conferred with ample power to determine the issue or the matter before it. See, again, it has not been defined. Now, court is expressing it by way of adjudicating in a formal way or expression. Now, formal expression here means once the directive or the order decision is made, it is written, signed and sealed. Written and signed by the court. Therefore, it is not informal, it is formal. Now, here in order we have discussed that again formal expression of any decision, it means it is also a formal, order is also a formal expression because it is also signed and stamped. But there could be many orders in a suit, but there could be only one decree. We will study it further that there are kinds of decree, preliminary, final, partly preliminary, partly final. This we would discuss in another session. But there would be a one decree, whereas in a suit there could be hundreds of orders. For example, while deciding a suit, an application comes preferred by the first party that ad interim relief should be given to him. This application is decided and order is passed. The application is preferred again for the amendment of the pleading that sir I have left it, I did not incorporate because it was not in my knowledge, now I be allowed. So again order 6 rule 17 amendment could be allowed and order could be passed to the side. Then the application with regard to attachment before judgment or number of applications in a suit, it takes place during the process of adjudication. Then on each and every application, even if you simply seek adjournment from the court and the order is passed, which is we call it as Jimny order passed on a day-to-day basis. These are also ordered because formal expressions. But every order is not appealable. Fine. So we will read it further. Any adjudication from which an appeal lies as an appeal from an order which is appealable is not a decree. Now, the court expressing it conclusively determines the right of the parties with regard to all or any matter in the controversy. Now, again, one major difference is that decree conclusively determines the right of the party to the suit with regard to all or any matter in the controversy. So, it decides the right conclusively, whereas in order does not happen so. So, again, this is the major difference. Fine. As I said, there could be number of orders in a suit at different stages. Every order is not appealable and it does not determine the rights conclusively, and it could only be filed, it could be filed in applications, petitions and also in a suit, whereas the decree is always drawn in a suit. So, if you will understand the similarity and the difference of the two, then I think you would be able to derive the true meaning of the decree. The kind of decree and deemed decree, these concepts we would be sharing in the forthcoming lecture. Now, as far as judgment is concerned, it has been defined under section 2(9). See, decree is always followed by the judgment and it is rather based upon the judgment. Now, judgment is a well-grounded reasoning given by the court after framing the issue and appreciating the facts of the case. There are two parties, litigants come before the court, they give their narrative by way of the plaint and the written statement, then out of that the issues are framed. Once the issues are framed, then issue-wise finding and reasoning is given by the court after examining the witness and perusing the material which is produced before the court for the inspection and the judicial scrutiny. Now, after appreciating the whole thing, a judgment is drawn. So, the simple meaning here is that if you see the essential, a concise statement of the case means facts of the case, points of determination means the issue which is framed and a decision on those issues, and ultimately the reason for such decision which actually prompts the court to come to the conclusion and decide the matter. So, this is the meaning of the judgment. And as I said that few orders are appealable, the appealable order have been provided under section 104, and order 43 rule 1 deals with it. The list has been provided as to what are the orders against which the appeal could be. Similarly, decree is appealable because the appeal is always filed against the decree, not against the judgment. Fine. If you will read section 96 of first appeal, it would be clarified to you. Second appeal also one can file. Fine. Under section 100, the entire procedure has been described as to but there has to, this the ground that there has to be a substantial question of law. If it is involved, then the regular second appeal could be filed before the High Court. Similarly, the later patent appeal and the other things regarding the appeal, there are 2-3 provisions like, when appeal cannot be filed, or what is the concept of appeal we will be discussing in the later course of our discussions and the lectures, but as of now it is enough. I hope that you have been able to understand the meaning of the decree very clearly, that which say that formal expressions. I have also already made it very clear. Then I have discussed the court, and then the conclusively determines the rights of the party and what is the difference between the formal expression and the informal expressions, and under what circumstances the decree could be given, passed by the court. And my dear friends, this is I think enough for today. Thank you very much.